Greetings, loved ones. Lately on the chat, there has been some question as to why is the court receiving my paperwork with such hostility with regards to equity and everything we're doing here. This is coming from Amicus Curiae, otherwise known as Brother Tony. And just let me fill you all in on a little something here. I'm just going to read it. It's not quite a page, but check this out. Okay, so this is Canada and US, as in United States, equity versus England and Australia. Okay, so this comes from the Uniform Law Conference of Canada, Civil Law Section, Uniform and Simplified Trust Indenture Legislation. Okay, so I'm going to jump right to number 2, Executive Summary. Legislation regulating trust indentures is unique to North America. There is no corresponding legislation in effect in the United Kingdom, Australia, or the European Union. Canadian legislation is largely modeled on the American Trust Indenture Act of 1939, although the Canadian version is not as expansive in scope. This legislation must be seen as part of a broader package of legislative remedies designed to protect investors in debt instruments. Okay, because we're dealing with debt, instruments is important. Instruments, as we know, this is going to be something on paper, some type of wording with numbers, and it's going to be doing things as it's evidence of a transaction is what this technically is. And through this transaction is a transfer, as we've always mentioned in the past. Okay, so we got to get our heads wrapped around debt instruments, or instruments generally. And as we can see, what just happened to Australia, the European Union, and the United Kingdom. Tough go, guys. You may recall at the beginning of when this came out, several years ago, I remember doing a video, posting a quick video about how the world's going to need mine and my brother's help here right away to get over this problem with the vid. And that's why we came forward with the entire adverse claim perspective, and how to instantly generate a document or a notice that you could give to someone knocking on your door, saying that we're about to kick in your door and give you that injection that you may not want. So we were trying to provide a little bit of remedy, but long story short, what we were conveying here, without me honestly even knowing it at the time, when I said you're all going to need our help, what I'm saying is the United States or Canada is going to have to come to your rescue to help infill legislative remedies that your countries are absent in. And I didn't write the date here on this Uniform Law Conference of Canada. I just forgot to put that in, but trust me, this is fresh. This isn't 100-year-old legislation that I'm quoting here. So we need to be mindful of the class proceeding and what it's meant to do. This is Enactment Remedial is what it's called, where you can grab legislation from Canada / British Columbia specifically and bring it into your court case in England, the United Kingdom, Australia, wherever you are. Because as it stands, your legislative ability is severely limited. Now here's the problem with the Canadian version versus the American version. Trust indentures are only brought or recognized or are valid under the Corporations Act of Canada. Okay, well, see how that's a bit of an oxymoron? Now they're literally saying that you have to have a valid corporation to bring a trust indenture through. And this trust indenture, again, being the instrument, is between that corporate body, its directors, shareholders, voting members, Oh, here's the cool thing about the American version. The American version is saying, no, shouldn't be brought under the Corporations Act. It ought to be brought under the Securities Act, which is a completely different venue. And this is why the American version is actually more advantageous than the Canadian version. When a man or woman is dealing with trusts or security agreements, moving security interests as they relate to security entitlements. This is all afforded under the securities laws, which means you don't have to go and create a corporation. Now, I know a lot of people are going to say out there that, yeah, but the birth certificate is evidence of a corporation. Look, it's a registered person within her Majesty's, sphere, and it ought to be regarded as a corporation / person. I'm just suggesting that the more formal interpretation of that act is that they want you to go have a corporation or a non-corporation brought under those acts, the Corporations Act, and it's developed from there so that it can be recognized. So this puts us into a situation where we can, as Canadians, rely on provincial legislation, which also, again, falls under corporations, oddly enough. The 1939 Act in the United States does provide the, as it stands today, the ultimate remedy to have your trust indenture heard without having to go through corporations and things of that nature. Because again, now we're trying to commingle equity into a legal corporate structure, which makes sense if you want the legal system to actually recognize it. However, there's a better alternative, and it's just through the Securities Act and the securities transfers. And now we had another brother here. I remember not long ago he was suggesting that, oh, where I am, we don't even have a Securities Transfer Act. Okay, so there's another alarm, another red flag going off that if your state, province, or territory has nil for securities transfers and legislation to deal with those, that's a hurting place to be. You're going to have to bring in this remedial enactment from Canada or the United States. Now again, now back to the class proceeding. The class proceeding is merely, at its very least, going to declare the rights of class and subclass members. And this declaration is going to be by, say, decree of the court, saying that the class and the subclass members are to be treated a certain way, and the Crown, state, province, or territory must comply with the orders from that security entitlement holder or that beneficiary, or this sleight of hand. Scripture used to call it a bond of peace. This is in the Wycliffe version. And a bill of peace and equity may be petitioned to the court if it's worded properly. So we need to just, again, be mindful now of debt instruments. What do you put down as a trust expression? Again, this would be a resulting trust or a security agreement. Take your pick. They're not quite the same, but they afford similar outlook. But remember, when we were deemed to be born into sin, primarily. Secondly, back that up with the War Measures Acts that were literally declared and enacted around the world, declaring who the enemies of the state are. And because we're deemed to be public enemies in adverse possession of an interest that truly belongs to His or Her Majesty and right of, or if you're in the States, to the United States, we need to create a new covenant, alliance, friendship, or agreement. Consider that to be a treaty. If you're deemed to be at war, other than surrendering, what's your next move? Well, here's my peace treaty. So unless you're dealing with words of this nature, the courts are going to be frowning on you right from the get-go. To better answer our other brother's question, there's why is all my good stuff here being met with such hostility? Here's part of the problems. So now, when consider the Lord's Prayer, forgive us of our debts, not forgive us of our trespasses. Remember, that was the little switcheroo. It's forgive us our debts. So in order to forgive your debt, you ought to be proficient at how to create an instrument that would clear such debt. And such instrument is perfecting one's interests in a certain collateral or a certain property that you must describe appropriately. So I just wanted to rip this by everyone's attention here. And again, you can afford your own space to go ahead and try to implement and bring in this remedial stuff from North America, US and Canada, to help you in your cause for those on the England side of the ocean from us. Or joining the class proceeding, like I said, I've got this all is laid out, and it provides for the multi-jurisdictional class proceeding and multi-jurisdictional disclosure. So you can disclose something in Australia using British Columbia's legislation to bring it back to be favorable for you. And again, also applies to the entire European Union and England. So big piece of the puzzle there, people, as to why we're getting our heads banged against the wall. And I hope this provides a little bit of direction, maybe a little bit of extra hope, and maybe a little extra, yeah, I better join that class proceeding, or at least I know how to go over here now, which I've kind of got it structured so that you can navigate that on your own, but you're ultimately going to get deflected back to a proceeding that already exists, and they would rather just join you to that thing because it already exists. Either way, we'll see you soon. Okay, loved ones.